Thanks, everyone. Our final session features a panel discussion focusing on how to find common ground in relation to fostering the pathway for renewables and oil and gas to coexist. Please welcome our panelists, Melissa Miller, Co-Chair, Senior Vice President, Development for CleanTX, Raina Hornaday, General Manager and Co-Founder of Caprock Renewables, Cliff Squibb, Partner with Munsch Hardt, and Laura Bowen, Attorney with Braun and Gresham. Moderating today's panel is Jonathan Grammer, President of Grammer Land and Exploration.
All right, thank you, Leanne. The title of the panel discussion is Common Ground, How Solar and Oil and Gas can work together. And one of the initiatives that's going to be rolled out during this session that we want everybody to know about that I think is an important breakthrough for energy in Texas and certainly for NAPE and certainly for AAPL is AAPL has approved the first shared use agreement that's available to all of its members to address issues of concurrent development in the state of Texas. It can be found on their website, free to all members, and you can access it at landman.org under the menu for resources and select forms, and it went live this morning. And there are some participants that need to be acknowledged and need to be thanked. AAPL would like to thank the Renewable Forum Subcommittee, including Laura Bowen, who's one of our panelists here today, and Melissa Perkins. Also, Doug Schmidt, Chair, Larry Koshow, Assistant Chair, Brent Hilliard, Carla Henderson, Matthew Madison, Director of Underwriting for Stewart Title Energy Group, and John Casey, Senior Land Advisor at Devon Energy. Before we begin the Q&A for this panel, I'm going to give the panelists an opportunity to introduce themselves and tell us all a little bit about what they do.
Thank you, Jonathan. Do you want to tell us about you first?
Oh, yes. That's a good idea. Jonathan Grammer. Founded Grammer Land and Exploration Corp. 20 years ago. We are a land services and acquisition company. We also own mineral rights in 62 counties in 5 states in the United States. We've developed about 22,000 acres of solar. I've done various oil and gas projects throughout my career, and that's why I was brought in today to moderate this panel.
And you're on the board of CleanTX.
And I'm on the board of CleanTX, that's right.
You're like a hybrid. You do both. I'm Raina Hornaday. I am the co-founder of Caprock Renewables. We do utility-scale solar developments throughout Texas. My background's utility-scale wind, and I also work in the microgrid space, which is interesting, and we feel like it's up and coming. I serve on the board of CleanTX with Melissa and work with a lot of the ladies here and gentlemen. So nice to meet you all. Thank you for having us.
Thanks, Raina. My name is Melissa Miller, and I am the Senior Vice President of Development for Eolian Energy. So hail from wind and solar background for about 20 years, and then about the past 2 years doing large-scale, exclusively battery energy storage development. But what I'm here today for is I'm the co-chair of the board for CleanTX, a nonprofit that is a statewide group that the doors are open for an all-of-the-above approach to energy. And we're really excited to be here today, and I will pass it on.
Hi, everybody. My name is Laura Bowen. I'm a 5th-generation Texas cattle rancher, and I was ranching with my family, and we decided somebody needs to go to law school to know what we've been signing. That person was me. I got into long-term surface leasing because my family has now a solar facility on us and a wind facility. And I wanted to help other people in this space, so primarily I'm helping farmers and ranchers in Texas and through SPP navigating these early stages, and this certainly includes mineral accommodation. Last I counted, I've helped, I think, 50 different projects, groups of landowners all over the United States, so I'm very proud. And I've seen quite a bit of different approaches to the agreements we're going to talk about today, so I'm here to add color, I think, to this conversation.
My name's Squibb. I am an attorney with a firm called Munsch Hardt. Until recently, I had the pleasure of working with Melissa Perkins, who was mentioned earlier as one of the key drafters of the joint use form. So thank you for all of those who were involved in that. I think it's great. My focus is kind of on the, I might be more of the oil and gas voice among the members of the panel. I have less experience in renewables than a lot of the people to my left, but I do have a lot of clients in the oil and gas space who are very interested. Some of them are just curious, some of them are interested, some of them are working through how to cooperate or whether to cooperate with oil and gas, with renewable development. So it's an interesting time for sure to be in the industry and to see what kinds of opportunities and challenges there are out there. Primarily, I'm kind of a half dirt lawyer, half kind of A&D corporate lawyer. So that's the perspective that I'm bringing today.
With the title being Common Ground, the participants and all of us in the state of Texas are trying to find not only the figurative common ground, but the literal common ground, literally out on site locations where concurrent development is ongoing between solar and between oil and gas. And I was going to ask the panelists if one of you could answer, when we talk about common ground and the motivation for finding it, why is this important?
All right. So what I wanted to cover on that question is my experience as being involved as a landman starting in early 2000, knocking on doors for wind, and what I've seen over the past 20 years working with landowners, and just kind of underscore that, we know that Texas is 95% privately held land. We also know that we have the 8th largest economy in the world here in Texas. We know we're an energy leader in oil and gas and natural gas and wind. We're number 1. We're number 2 in solar. We're going to be number 1 in solar next year. So knowing all of that, how did we get here if we didn't make that an active choice? If landowners didn't make that an active choice, if our industry didn't make that an active choice? We got here because we are an energy leader. And so this is awesome that we're having this conversation today. And so I do co-chair the board of CleanTX. We reached out to AAPL, heard about the good work that Melissa and Laura and Cliff and others were doing on the shared use agreement. Really excited about that. Super important conversation about how do we work together. And so it's a really great opportunity.
Laura, you mentioned the mineral waiver, and I guess before we go too far, there may be people in the audience that may not know exactly what we're talking about when we're talking about a mineral waiver. So tell us a little bit about when we say a mineral waiver as it relates to a solar development, or I guess any surface development, what are we talking about?
And I think you hit the nail on the head there. This is certainly not something that just affects solar, but because solar has become such a big part of the Texas industry and it's moving into these spaces that are traditionally oil and gas producing areas, we're starting to see these agreements come out of the solar space, and they can take on many different flavors because of course we know how the surface is held versus how the minerals are held may be different from project to project. We may be leased, we may be unleased, and then the agreements that come along with that presented by the solar company to the mineral owners or to the mineral developer can take on different forms. So where we started in this industry 5 years ago, I would see many surface waivers. And a surface waiver would be, we want you to waive all your rights to the surface, full stop. This is perpetual. We're going to hold this in perpetuity. And that obviously is not something that is interesting to a mineral owner or a mineral lessee. Frankly, I was in situations where I said, we're going to throw this one in the trash. If they really want it, they're going to come back in 6 months with a better offer. And sure enough, they would come back in 6 months with a better offer. And through that process, a lot of the negotiating and working together, we started to move into the mineral accommodation space. So this is the agreement perhaps you're familiar with, where we're talking about how far are we setting back our surface facilities from your drilling facilities? How are we using roads? How are we sharing potentially in utilities? That's the mineral accommodation side. So rather than you can't use the surface, full stop, how can we work together? And from those conversations, obviously different companies have different forms. We were hoping to bring something that the industry at large could start with, and that's where we started working 2 years ago on the joint use agreement. That's going to be your solar developer and your oil and gas operator, and we were incredibly proud of that form and all of the eyes that it got in front of, because it is workable. The feedback that we got from the industry is yes, we could take a form like this, because we as the solar company have our space, and then you as mineral owner have some relative assurance that you can continue to operate on this project, and we can be there together.
And what's the greatest challenge for the panel in trying to obtain these mineral waivers that you face?
I have personal experience with this.
Go ahead.
I think a lot of it is information based and education, because a lot of who we work with, whether it's landowners or county commissioners or especially the operators, and there's also mineral owners too, so it's not just the operator. It's just an education, and that's one reason that Melissa and I are so passionate and put so much time and effort into CleanTX, because it's kind of a way for us as developers to have a non-kind of sales pitch and communicate to people in the industry, people that are interested in the industry, what the best practices are. So we have webinars and we have conferences, and we support other conferences to try to come together so we all can agree on what is the best way to develop solar on top of a active lease, and how do you deal with the mineral owners, and attorneys are a big part of it. There's 3 on this panel, so it's all a very intense legal agreement. One thing I think that hasn't been mentioned that's very important is the engineering side and the petroleum engineers, and that's one of the things we really look at is what is the potential for the piece of property. And I didn't mention when I did my intro, but Laura and I have the 5th generation in common. You probably are 5th generation. Are you first?
Texan?
No, landowner.
Oh, landowner? Oh, yeah, at least 4th or 5th. Yeah.
5th sounds good.
Yeah.
Yeah. So I'm 5th generation landowner, have a ranch in eastern New Mexico. So we don't have oil and gas there. So this has been a big learning curve for me. But I do advocate for the landowners on these projects, which often, because of the history of oil and gas in Texas, aren't the same as the mineral owner. So it's very complicated. It's very important work. So getting everyone to agree, which we've done. I've developed about 1 gigawatt of solar, and some of it's on the ground and some of it's under construction. And I think there's been hundreds of thousands of other acres that are leased. So these agreements have moved forward. They are happening. But I think a lot of it is just important education on what solar is and how it can coexist with what else is going on the existing acreage.
I don't have much to say, but I want to ask a question of you, Raina, because I think this is an important audience. So when we talk about petroleum engineers, where are they in this conversation, and how has that changed over the last 5 years? Because maybe in my experience they weren't there in the beginning, and that was part of the problem, because we're looking, Permian Basin, Eagle Ford Shale, we're looking at potential development of oil and gas, and you say to me, solar company, full stop, you're waiving the surface. How can a petroleum engineer play into that?
So do you want to trade sheets? No. So that's one of the things I wanted to bring up is if we're working with an oil and gas operator, we've worked with a wide variety of different groups, but sometimes they, if there's an active lease, then they're going to know their drill plan. And they move a lot faster than us in some cases. They'll have a drill plan and they'll build it out by the time we, get to our next step. So that's been interesting to see and just an important part of it. And that's better because then they have we don't want to be doing construction at the same time. That's an important point. Shared roads has always, even in the wind space, like how we share the roads and the payments associated with that are, hey, Stacy, are important. So, but sometimes, like if we're leasing land that there's not an active lease, but we still have to get the waivers and accommodations, we'll hire our own petroleum engineers to analyze what the potential is for an operator that might come in. So I think it's like a lot in the renewable space. It's a great opportunity for oil and gas companies to get into renewables and just provide that service. And I'm sure there's folks in this room that do that analyze how they would be coexisting. Stacy could probably speak to it.
What is the potential, if any, for solar development to help alleviate stranded energy costs for oil and gas development in far reaches of West Texas and other parts that may be paying 15 to 20% for utility costs to run their pump jacks and pumping units, or may not have distribution or transmission in their area at all? What can solar perhaps do for these operators?
I think there are opportunities for oil and gas companies to become sort of investors or developers on sort of a micro scale within the renewable energy space, or to work with more established solar developers to accomplish that. There's law that says an oil and gas operator can use so much of the surface as is reasonably necessary to develop the mineral estate on that particular tract of land that's leased or a pooled unit. You can envision situations where an operator might use solar to power oil and gas operations. If we're talking about a bigger field, there are some areas where the operation, the solar facility might not be perfectly right sized to match the power demands of that particular tract or unit. And so, there's kind of a legal gray area in terms of if the operator is producing excess energy, is it permissible? And that's something I think that might become more and more of a legal issue at least in Texas, for courts to address. Is the excess energy that's being produced by solar developers just incidental and therefore permissible? Or is it kind of an end in itself and it's exceeding the oil and gas operator's right to use the surface? So, there can be situations where, an oil and gas operator might have the ability to use solar under the rights of its lease, without undertaking some big massive solar project. And I think that's important to keep in mind. In terms of the economics, I'm a humble lawyer, not a numbers guy, but I certainly would think that there would be opportunities for where use of solar would make sense in terms of getting costs down and making production viable that might not be viable otherwise.
You mentioned the word accommodation. We're now probably, at least 10 years into really intensive solar development in Texas. Other than the one standalone case that I know of, Lyle versus Midway Solar, how is the accommodation doctrine evolving in the courts, if at all?
Well, correct me if I'm wrong. We haven't had anything since Lyle v. Midway.
I think that's right.
So, Lyle v. Midway, for those of you who aren't familiar, I'll give you the highlights. It is solar overlying mineral estate. There's some issues. It runs all the way up to the El Paso Court of Appeals. And the question is, will the accommodation doctrine dictate how these two estates work together? Question affirmed by the El Paso Court of Appeals. yes, we're going to use the accommodation doctrine. The tricky part of Lyle is that the underlying mineral owner had not been leased and had no plans to lease in the future. And so while the overlying solar facility, the Midway Solar Facility, did have accommodations, it had an 80-acre tract and a 17-acre tract free of panels, with the intention that they should come in there and drill in the future on these two open tracts. The question was, is that enough? And we don't know yet. And so a lot of what we're doing on this panel is trying to avoid answering that question in the courts of law. We want to get everybody to the table and talk about what is it that you need, mineral developer. How can we make space for you? And of course that looks different for every project. If we are in, say, West Texas, I have a couple agreements right now. We're looking at large laterals. How much space do we need for these super pad sites? That looks very different than maybe North Texas, where we've got shallow verticals, and we need to overlie our drilling corridor, or our drilling set aside right over that productive formation. And so the geology, back to Raina's point earlier, that goes into those conversations needs to happen in early negotiations, because that's a lot of times where we're setting aside that acreage. And we're maybe planning, for drilling 10, 20, 30 years out in the future. We're hoping that we get it right. And we certainly have done our due diligence, but I think even this conversation up here is going to change in the future as we see new drilling, new technologies, new things coming off of the, or out of the mineral agreements. And certainly Cliff can speak to this. He's been writing in the geothermal space. How is this conversation on solar going to evolve in the future as we see some of these new technologies come in?
Yeah, just to ride your coattails, and I'm glad you fielded the Lyle versus Midway question, because you knew the facts a lot better than I did. There are plenty of reasons why oil and gas operators will have an incentive to cooperate with solar and other kinds of renewable development. And we can get into subsurface issues perhaps a little later, or not at all. But surface owners are part of the oil and gas community. They're not part of the operator community, but they are part of the oil and gas community, landowners. And, there are a lot of savvy people, many of them here at this conference, who have strategically acquired surface, and they like to monetize it. And, I guess what I would say from the operator perspective is you never know when you're going to need something from somebody. And so there are surface owners who want to monetize their assets, want solar development to proceed. On the other side, there are oil and gas operators who might be drilling allocation wells, and they want to put a pad site on a property. That pad site's footprint is going to exceed the size that it would if it were strictly operating a lease well and not an allocation well. There are operators who want to locate saltwater disposal wells that take off-lease water, maybe not quite commercial saltwater disposal wells, but nonetheless they want to use the saltwater disposal well to bring in water from off-site. And to do that, you need cooperation with the landowner. And so sometimes I feel like the landowner is the key for kind of what it takes to unlock cooperation between oil and gas operators and solar developers.
And it also sounds like on a larger scale, we're not just teeing up concurrent development between oil and gas and solar. We're teeing up concurrent development for all these potential energy sources: water disposition, lithium extraction, carbon storage, solar, the whole gamut, to maximize the GDP, not only for the state of Texas, but for all these landowners and these natural resource owners. And that concludes, unless I've left something out, the topics that we had intended to cover. And with the time left, I think they're going to allow us to open it up to questions if anybody would like to submit one to the panel. Seeing none, we appreciate your time. Let's thank our panelists. Appreciate it very much. Thank you.